good day, everybody. In honor of the United States passing the Guiding and Establishing National Innovation in U.S. Stablecoins Act, or the Genius Act, thought it'd be a good time to dive back into the actual final legislation and take a look at really what it says firsthand, beyond just what you maybe read in the paper or hear on the news or from colleagues. We're going to go right through the act line by line. I've gone through, and if you've been here before, I've read this already. I've kind of highlighted what I think are pertinent and important points. You may disagree, you may agree. That's great. It's a democracy. Keep in mind, I'm not a tax professional. I'm also not a lawyer. So I'm coming at this from, a number of years in banking and dealing with legal documents, and also obviously in public accounting, where I was a valuation specialist and having to read agreements there. And words always have meaning. Now, obviously, the interpretation of these documents is really different from everyone, from the creators who made it, through the users that use it, and then ultimately, if there's any kind of litigation, any sort of judge that decides how the words themselves should be interpreted. So this is a best guess. But the things I can look for, and as a layperson, you can look for in these things, is the phraseology that's used, the terminology. It gives you a sense of the level of sophistication behind the act. You also can get a sense of what's important, because typically legislation and rules are written in sort of rank order of priority, either intentional or unintentional. It's very rare that you see the headline of the act buried per se. But we're going to do our best to go through this. If maybe you're listening to this while you're driving, feel free to go and download the act yourself afterwards and kind of check my work. Again, the way this will work is I'm going to share my screen. We're going to scroll through the section. I've highlighted some terms because I've read through it already. I've maybe made some marks and notations. These marks and notations are my own, and they're not the opinion of any company or group or anything that I'm affiliated with. This is simply my attempt to learn as we go, and we'll have at it. So I'm going to go ahead and share my screen, and here you see this is a copy of the Act S1582. This is readily available to everybody. This version has not yet been signed by the president. This is the version, however, that was approved by the House and both the Senate. For the sake of time, this is only 45 pages, and I say only because some of the things we've gone over have been hundreds of pages. But I'm going to break this up even further. We're going to kind of start with sort of the preamble and some of the definitions, and then in later videos go into some of the meat and potatoes of what that section is speaking to. So this way it's a little bit more digestible. So this is a typically 119th Congress of the United States. Here it says the Genius Act. We've already identified that as being the one we're chatting about today. Here, beginning with definitions, right? So the appropriate federal banking agency, I was curious what appropriate banking agency means. And so for the national banks, it's the comptroller. For the state, it's going to be the board of governors, maybe the division of banking. The Federal Reserve System does have authority over state chartered banks to a certain extent. And then here also for state non-member banks, but that have insured branches, it looks like the FDIC. So right up front, we're looking at this act applying to entities that have an appropriate federal banking agency or state bankruptcy, not bankruptcy, a state agency associated with them. That is an important one of those things where what's not said is also important, since we are strictly referring to and defining entities that have an appropriate federal banking agency or state agency. You can tell right away that this is really going to exclude a lot of players before you even jump in. The board, when you see the word board, it's going to be referring to the board of governors for the Fed, the comptroller of the currency, and then corporation is FDIC. That's important because you wouldn't know that otherwise. So if you see corporation, they're talking about FDIC. If they're talking about board, they're talking about the Fed. What's interesting here is digital asset means any digital representation of value that's recorded on a cryptographically secured distributed ledger. Concise, tight, clean definition. Clearly, this has evolved if you've looked at prior language and how they've kind of tried to really over-explain what it is. And a digital asset service provider, this is also very important here, right? So you have Congress that's creating a law around stablecoins, and they are defining what a digital asset is. And they're also going to define what a digital asset service provider is. And the reason why this is important is because as other acts start to bubble up, or there are state rules, or other, say, federal departments start to issue proclamations and guidance, et cetera, they're going to use and pick up this language. So when in the United States, in the the regulatory realm, they talk about a digital asset service provider. In this case, they're saying for companies that operate in the U.S. or on behalf of U.S. customers, entities that exchange digital assets for monetary value, like a Coinbase, right? Exchanging digital assets for other digital assets, samesies, transferring digital assets to a third party, acting as a digital asset custodian, maybe like a BitGo or an Anchorage, participating in financial services relating to digital asset issuance. So that may be broker dealers if you're looking to issue maybe an RWA or something, but related to financial services. That makes me also think they're going to trip SEC and broker dealer rules here potentially. But what it doesn't conclude is interesting, right? So the protocol itself, you launch a protocol, you are not, if you're a protocol launcher, you are not a digital asset service provider. You are just the protocol. If your company develops, operates protocols or self-custodial software, or as a self-custodial software interface, so like MetaMask, if you're a validator or if you're participating in a liquidity pool, none of those qualify you as a digital asset service provider. So in essence, they're really focusing on what? Who holds stuff and who transfers stuff, especially in exchange right up front for monetary value. The first thing they want you to point out is that if you're an entity that helps you go from crypto to cash, you are likely falling under the purview of a digital asset service provider, or the definition of a digital asset service provider. Distributed ledger, they talk about it being a public digital ledger and used to link data. Now, it doesn't say a private ledger, right? Like a private protocol. So maybe that's excluded. Whether something is a public distributed digital ledger or a private ledger, I'm sure is going to be one of the arguments that makes its way through the courts, even with this act in place. And here, distributed ledger protocol means a publicly available and accessible executable software deployed to a distributed ledger. So you have to have a public digital ledger. And then the protocol is the thing which operates on the public digital ledger. And those terms are going to be important. A federal branch, just so you know, this is like a U.S. branch of a foreign bank. So they're going to talk about federal branches or branches. And that may come into play a little later as to who can be a qualified issuer. And then here, the next definition, federal qualified payment stablecoin issuer. So right off the bat, who is the act saying can be a federal qualified payment stablecoin issuer? It could be a non-bank entity, but one that's approved by the comptroller to issue payment stablecoins. So I'm trying to think offhand if I can think maybe Paxos, right? Paxos is a non-bank entity as of the date of this broadcast. And so it's possible that they could get approved by the comptroller. They would be a non-bank entity approved by the comptroller to issue stablecoins. An uninsured national bank, and then here a foreign bank. So here it is possible that a US branch of a foreign bank could be a federal qualified payment stablecoin issuer. A foreign payment stablecoin issuer is one that is organized under the laws of a foreign country, uh, or a territory of the US, Puerto Rico, Guam, our protectorates, and not a permitted payment stablecoin issuer. So right off the bat, if you are a payment stablecoin issuer and you are deemed foreign, you are not going to be a permitted stablecoin issuer. It's right here, boom to boom. So that means they want you in the lower 48, or at least have a branch here. An institutional affiliated party, that's going to come up, means where there's a director or officer of the payment stablecoin issuer. So I'm sure later they're going to talk about like who is responsible if things go sideways, and that's probably where they're going to bring that up. And then they don't want to leave out credit unions and depository institutions. And so those are mentioned as well as possible federal qualified payment providers. Lawful order. Now, the reason why I thought this was interesting is because here it actually talks about a lawful order that requires a person to burn payment stablecoins. The reason why that's interesting is I read a lot of these acts and regulations, and I don't recall ever seeing the word burn in them. To me, that represents a couple of things. One, it says that the language has, or the lexicon, right? The language of crypto has made its way into the hallowed halls and is actually in these legal agreements. So burn is a legal term. And people that are in Web3, what that generally means, we know, is sending the tokens to a place that they can never be retrieved. Or other form of dismantling of the token itself. Generally speaking, it means to send it to a wallet that no one has the power to send it from, as opposed to a complete an erasure of the token itself. So that'll be very interesting as to what functions qualify as burn outside the scope of this discussion. Payment stablecoins, monetary value means a national currency or deposit denominated in a national currency. And so monetary value is going to have a big part, it's going to play a big part in the discussion around stablecoins, because largely of what stablecoins aren't, which they are not securities. And the reason we know that is because we're going to see here where they talk about the designation of something as a security, they're talking about that as if it happens outside the four corners of the act. Money as a medium of exchange, nothing new here. What is a payment stablecoin? It's a digital asset, meaning we saw the definition. It's on a distributed ledger. It's on a public distributed ledger. Is a digital asset designed to be used as a means of payment or settlement, not cash management, right? So it doesn't say anything, and nothing that would imply yield bearing. Simply for the use of paying for something or settling a transaction where there needs to be a cash leg. And so it's a digital asset with an issuer that's obligated to convert, redeem, or repurchase for a fixed amount of monetary value, right? Currency or deposits, not including a digital asset denominated in a fixed amount of monetary value. Super interesting. In fact, I'm going to highlight that because I missed it on the first go round, right? So what this says right here is that a stable coin, a payment stable coin, is not one that it says a payment stable coin does not include a digital asset denominated in a fixed amount of monetary value. Is obligated to convert, an issuer which is obligated to convert for money, not including a digital asset denominated in a fixed amount of monetary value. So that is interesting. So the payment stablecoin is basically just that thing which can convert into cash and not necessarily something that can convert into another stablecoin. Um, that I think will be important because there might be some issuers that don't convert to cash, but convert you to another stablecoin. And there, that token is then not a payment stablecoin. Or that issuer doesn't qualify as part of this test to be considered a payment stablecoin. And then also the issuer represents that the issuer will maintain or create a reasonable expectation, a stable value. This is very loose, right? What does create a reasonable expectation mean? They put out a lot of Twitter, right? Or they go on LinkedIn and or they put out ads in the paper or billboards where they basically say, hey, look, we promise we're going to be there. So create a reasonable expectation is a very loose standard for the issuer. But there are other rules. And it does not include a digital asset that's a national currency. So this is your CBDCs. And in essence, what it's saying is that stable coins are not national currencies. Is a deposit. Here we go. Hold on. Let's see. This is it. Does not include. So payment stable coins do not include digital assets that are a CBDC. A bank deposit, right? So a tokenized deposit, not a payment stablecoin, or is a security, bond, note, evidence of indebtedness, or investment contract that was issued by the payment stablecoin issuer shall qualify as a security solely by virtue of its satisfying the conditions. So the idea here is that if the payment stablecoin issuer issues something else that's tokenized, that is a debt, that debt is not going to be a payment stablecoin. A payment stablecoin is something that is solely apart from the security, and it is solely apart from the national currency. It is this. Like, what is it? It is a digital asset issued by an issuer that's obligated to convert to cash and has created a reasonable expectation that they will do so. That's the payment stablecoin. So what is a permitted payment stablecoin issuer? Has to be formed in the US, right? Nothing extraterritorial. It could be a subsidiary of an insured depository institution, a qualified payment stablecoin issuer, where we talked about those rules at the beginning of this chat, or a state qualified payment stablecoin issuer. And we'll talk about state payment coin issuers later because they should call out what the rules are for the state to approve issuers so that you don't end up in a situation. They'll never be able to contradict. The state would never be able to charter a payment stablecoin issuer that where something about their existence or process contradicts the federal rule. But where the federal rule might be silent or might have actual more flexibility, the state can always be narrower. So the state can always be narrower. It can always kind of speak to things that the act is silent on, but it can never be broader than the federal definition. Again, not a lawyer, but that's my understanding. So primary federal payment stablecoin regulator, right? So who's the boss? Who's the big cheese making the call here? Well, with a credit union, it's the National Credit Union. With the bank, it's going to be the board, the federal qualified payment stablecoin issuer, the comptroller. So again, this is where I kind of think your Paxoses of the world would fall in. Like they would have kind of a special line for their stablecoin division right to the comptroller because that's the authority. We're going to talk about registered public accounting firms because obviously the proof of reserve is going to be a huge element here, just foreshadowing for the next episode. And then here, this is something I hadn't seen before. The Stablecoin Certification Review Committee, which includes the Secretary of Treasury, the chair of the Fed, and the chair of the FDIC, 1, 2, 3. And 2/3 of its members will serve as the committee being in session because they can pass that vote. We talked about the state chartered depository institutions, who's the state payment coin regulator? Like we said, anything that the state decides who's it going to be, who's going to be the rightful regulator in the state. It's legally established by the state and approved to issue payment stablecoins by a state payment regulator. So a state qualified payment stablecoin issuer is legally established under the state, approved by the state to issue stablecoins, is not an uninsured national bank, right? They don't want uninsured national banks. They don't want local branches of foreign banks or a subsidiary of a national bank. So right here, they're excluding a big chunk of folks from basically saying, hey, we're going to get a state charter and issue a token. No. If you want to be a stablecoin issuer at the federal level, you have to be something other than, so almost a non-bank state entity, maybe a trust. That might work, right? It's not an uninsured national bank. So a trust is not an uninsured national bank. They are not an insured depository institution. So there you go. So state trust would work. I think a subsidiary we went over. Okay. So issuance and treatment of payment stablecoins. So what are the limitations on the issuers? So for one, it's unlawful for a person other than permitted stablecoin issuers to issue a payment stablecoin in the United States. So what this act did is, as of today, or when it goes into effect, which we'll see later, if you don't fall in line with the act, then you're done, right? So I can imagine a number of platforms operating in the United States or that have United States citizens as customers are probably really pulling back at this point to say, okay, well, let's take them all off the table until we know which ones are going to be approved. Maybe not USDC or what have you, but USDT, we said all along, right? Like that, USDT does not have a chair at this table based on what we've read already. And so it'll be very interesting to see how those platforms get around it. Do they claim that USDT is basically is not a stable coin or a security or a treasury, and so somehow it can still exist on the platform, but under some commodity rule? We'll have to see, right? Some creative lawyering, but there's definitely a lot of dollars around to fight all these battles. It'll be unlawful for a digital asset service provider to offer or sell a payment stablecoin unless it's permitted. It shall be unlawful for any digital asset service provider, DASP, right, to sell in the United States a stablecoin issued by a foreign stablecoin issuer, unless the stablecoin issuer has the technological capability to comply and will comply with the terms of any lawful order or reciprocal arrangement. So it looks like if you are a foreign stablecoin and you want to still exist, there's an opportunity to approach at the federal level, not the state level. My guess is the comptroller, right? If you're a foreign entity, foreign non-bank entity, you're going to go to the comptroller. If you're a foreign bank entity that you're looking for special dispensation, then you're probably going to talk to the board. But it's a harder path, obviously. And in general, and this was included because we don't know what we don't know, and kudos to the folks that wrote this up because they were thinking in these terms, but that there could be limited exceptions called safe harbors that, as long as the safe harbor is consistent with the purpose of the act and limited in scope, it may apply to small transactions as determined by the Secretary of Treasury. There might be unusual or exigent circumstances where they need to provide the safe harbor, maybe a cross-border merger and acquisition, maybe a transfer of assets, the establishment of a business. There might be these windows of time where someone is acting as a payment stablecoin issuer, even though they don't intend to, and that requires special dispensation. And these are all just examples, right? There's no specific instance I can think of where where this would apply, except maybe the cross-border asset movement. And then what are the punishments? So this is pretty interesting, right? So if you knowingly violate a subsection, you'll be fined no more than $1 million for each violation and in prison for not more than 5 years or both. So does that mean me issuing a stable coin and trading it, is that one violation, or is selling it to 10 people 10 violations? Because this could either be a drop in the bucket compared to the billions of dollars in stable coin, that float out there, or it could be like a small price to pay considering all the other costs incurred to be a stablecoin issuer. And so I wonder what their intent was here. Did they think about every instance as a subsection violation, or do they look at every subsection as a one times a million? We'll see. I don't want to be the one to test that. So a stablecoin that's not issued by a permitted payment stablecoin issuer shall not be treated as cash or cash equivalent for accounting purposes, and that's very important if you're keeping the books and records and you're holding this non-qualified payment stablecoin. If it's not considered payment stablecoin, you can't treat it as cash. So it's going to be some sort of investment and be subject to all kinds of accounting rules around those investments and commodities and assets, not as something being equivalent to cash. It won't be eligible for margin, for commission merchants or derivatives clearing. Basically, you can't use a non-permitted coin for the acts that a broker dealer would, or an exchange would typically engage in. And it's not acceptable as a settlement asset. So if it is not a permitted stablecoin, you can't use it as a settlement instrument between banking organizations. You can't use it to facilitate exchange and settlement. You can't use it for margin and collateral clearing, and you can't account for it like cash. So they're really saying and of course you can't buy and sell it to people in the US. So if you are not a qualified permitted payment stablecoin issuer, you have very limited utility on this side of the law. Exempt transactions, some of the things that won't apply to are direct transfers between individuals, transfer between individual in the US and an individual abroad, but operating under the same parent company. So I need to move some record of value overseas. That's going to be excluded. And this could also be a way to get it out too, right? So like if I take USDT and I move from the US to a jurisdiction that might recognize USDT, that movement in and of itself isn't going to disqualify you. This does give you an exit door. And then to any transactions by means of software or hardware wallet. Again, great to see, right? Great to see the term hardware wallet. These people are Web3 savvy. That facilitates their own custody of digital assets. So they really are not looking at what happens on your self-custodied wallet. But, if you're an entity offering custody or banking or exchange or broker dealer or RIA services that involve digital assets, and you need a payment stablecoin for settlement and you want something cash equivalent, then they're telling you what you can do. So the next session is the requirements for issuing payment stablecoins, and this is where I'm going to stop today's episode. Again, Howard Krieger, not a tax attorney, not a tax specialist, also not an attorney, just somebody who is super interested in this space. I hope you found the information useful. If you do find it useful, please like and subscribe to this channel and keep your eyes out for more discussions, especially we're on page about 7 of 48. So there'll certainly be some more episodes to come from this. And with that in mind, I want to thank you all for taking your time to join today. Be good to one another. Bye.